Good morning, everyone. So while I've been deeply enthralled in the Murdaugh trial, watching every second of it, I've also been following the case of Lindsay Clancy. And when it first came out, my emotions were all over the board on it. And to be honest, they still are. Some of the things that we heard in the beginning when this first came out might not have been the actual reality. Here is her arraignment from yesterday, where she attended via Zoom from her hospital bed.
Good afternoon, Your Honor. Jennifer Sprague for the Commonwealth.
Good afternoon, Your Honor. Amanda Fowler for the Commonwealth.
Could I have counsel for Ms. Clancy identify himself for the record?
Good afternoon, Your Honor. Kevin Bennington. I represent Lindsay Clancy, who is appearing by Zoom, as I understand.
Okay, very good. I can see Ms. Clancy on the Zoom line. In this matter, this arraignment is being conducted at the assent of the parties, with Ms. Clancy participating from the hospital that she is in. This is done to ensure, and it's on Zoom, that the public has as much access as possible to court business. It also ensures any privacy rights of people doing business at the hospital and helps the hospital in dealing with what they need to deal with on a daily basis. And both sides have assented to doing the arraignment this way. At this point in time, there is court staff that is at the hospital. Mr. Jackson, can you hear me? And is Ms. Clancy in a position that the two of you can hear me? Yes, Your Honor.
Yes, Your Honor.
Thank you very much. Ms. Clancy, at any point in time, if you needed to speak to your attorney, you can indicate that you'd like to speak to your attorney, and we can make arrangements to go off record where you would be able to have a private call with your attorney if that became necessary. Very good. I will first here, I've had a chance to review the court filing in its entirety. I have had a chance, there were documentation from a treating surgeon, as well as some letters that were also submitted to the court. I have had a chance to review all of those documents. Commonwealth, I'll hear from you first.
Your Honor, I apologize. Excuse me, counsel. Your Honor, I would request, much like we do many times with an identification issue, that rather than have the Zoom focus directly on her, you know she can hear, you know she's able to understand what's going on based on the response by the court officer. I'd ask if they could just avert the camera somewhat so that she's not constantly center of that.
Yeah, I don't have a problem. Given the arrangements, I think it's fine the way it is. Okay, thank you.
Your Honor, shall the arraignment ended?
Yes, you may proceed with the arraignment, Mr. Clark.
Ms. Clancy, on docket 2359 CR 153, the court has a complaint charging you under 265 section 1, count 1 murder, juvenile 1. Count 2, 265 section 1 murder, juvenile 2. Count 3, 265 15D big A, strangulation or suffocation, juvenile 1. Count 4, 265 15D big A, strangulation, suffocation, juvenile 2. Count 5, 265 15D big A, strangulation or suffocation, juvenile 3. Count 6, 265 15A big A, assault and battery, dangerous weapon, two-way exercise rope, juvenile 1. Count 7, assault and battery, 265 15A with a dangerous weapon, two-way exercise rope, juvenile 2. And count 8, 265 15A, assault and battery, dangerous weapon, exercise rope, two-way juvenile 3. Ma'am, the plea of not guilty will be entered. Please be advised while this case is pending, any violation of state, federal, or local law may result in bail being revoked and be held without bail.
Commonwealth, I'll hear from you first.
Thank you, Your Honor. The Commonwealth is requesting that the defendant be held without bail based on the facts of the case, the strength of the Commonwealth's case, and the potential penalty. On Friday, January 27, 2023, using an erasable whiteboard because she was still temporarily intubated, one of the first questions that Lindsay Clancy asked was, "Do I need an attorney?" She knew that she had murdered her children, and she had the clarity, focus, and mental acumen to focus on protecting her own rights and interests. The following is a summary of the events that led to the murders of Cora Clancy, Dawson Clancy, and Callan Clancy. On the morning of Tuesday, January 24th, 2023, the defendant took her 5-year-old daughter, Cora, to the pediatrician's for an appointment. She interacted with a receptionist, nursing staff, and a doctor. There were apparently no issues with the defendant's demeanor or behavior as she completed the appointment and was allowed to leave with Cora without any issues or concerns. When she returned home, she went outside with Cora and her 3-year-old son, Dawson, to play in the snow. They built a snowman. The defendant sent photos to her mother and to the defendant, to her husband. She texted with them. Nothing in the text was out of the ordinary or any sign of any distress or trouble. Back inside later that day at 4:02 p.m., the defendant searched on her phone, Kids Miralax. She then searched that Takeout 3V via her cell phone at 4:13 p.m. Immediately after doing that, she used Apple Maps on her phone to determine how long it would take someone to drive from her home in Duxbury to 3V restaurant in Plymouth. So she would know how long someone would be gone if they ran that errand. She next went on the CVS website at 4:47 p.m. and then called CVS on Summer Street in Kingston. She spoke to the manager of CVS and asked if they had the Kids Miralax. The manager told her no, but they had other similar medications. According to the manager of CVS, her voice did not sound slurred or impaired in any way. She had no trouble understanding the defendant, and it was a perfectly normal conversation. At 4:53 p.m., the defendant texted her husband, who was working in his home office in their basement. She texted, "Any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day." This was an unusual request, as when the family ordered takeout, they'd usually go somewhere closer to home, but it was a place that they had been in the past. Patrick Clancy texted back yes, and then the defendant asked him to check the menu. At 5:06 p.m., the husband texted the defendant asking what she was going to get. She responded, "A Mediterranean power bowl." She spelled it correctly, and it was something that was on the menu. He then told her that he wanted the scallop and pork belly risotto. At 5:10 p.m., the defendant called 3V Restaurant to place the order. She got the order correct. She gave the correct name for pickup, Patrick. The hostess who took the call said there was nothing out of the ordinary about this call. She was able to understand the defendant, that her voice was not slurred or impaired in any way. At 5:15 p.m., Patrick Clancy headed out the door to run these errands at the defendant's request. As he left, she texted him Pedialyte liquid stool softener. Surveillance footage shows Mr. Clancy at CVS on Summer Street in Kingston at 5:32 p.m. He goes to the medication aisle, the children's medication aisle. Phone records show that he called the defendant at 5:33 p.m. and she did not answer the phone. She then calls him back at 5:34 p.m. and the call lasted 14 seconds. He's there at the store, unsure of which medication to get, and she tells him exactly what she wants. He had no issues communicating with her. It was a completely normal call, although he did mention that she seemed like she was in the middle of something. He is on surveillance footage during this time, exiting that aisle and appeared to be using his phone. He then heads to the register, makes his purchase, and leaves the store at 5:37 p.m. He's next seen on footage at 3V Restaurant at 5:54 p.m. He picks up the food and he's out of there within a minute. When he arrives home, the first thing he noticed was the silence. He did not see or hear the defendant or the children. He actually called her cell phone at 6:09 p.m. looking for them, and she did not answer. He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding. She was conscious. He called 911. During this time, he asked the defendant, "What did you do?" She responded to him, "I tried to kill myself and jumped out the window." During the 911 call, Patrick can be heard asking the defendant, "Where are the kids?" He later told police that she replied, "In the basement." So immediately after this happened, she knew what she had done and she knew where the kids were. When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes. Cora and Callan were on the floor in the den area of the finished basement, which is to the left when you walk down the stairs, while Dawson was alone on the floor in his father's home office, which is to the right when you go down the stairs. Each child still had the exercise band that was used to strangle them tied around their necks when their father found them. Dawson and Callan were face down on the floor. Cora was on her side with her torso turned towards the floor. He removed the bands and begged them to breathe. He continued to scream uncontrollably and scream for officers to come to the basement. The dispatchers are hearing this and they send help down to the basement. And when they encounter Patrick, he yells out, "She killed the kids." The police rushed the children to ambulances that brought them to the hospital. And unfortunately, Cora and Dawson were declared dead at the hospital. Callan was med-flighted to Boston Children's Hospital. Medical staff was able to restart his pulse, but not his brain activity. He was placed on life support for several days before passing away. The defendant was transported to South Shore Hospital and then to a Boston area hospital where she remains. She sustained several broken bones in her back and her rib cage. The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24th, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech. In all of her writing, she appears to know who she is, where she is, the date, and with whom she's interacted. She wrote a note on her phone the day before killing the children, stating that she had, quote, "a touch of postpartum anxiety," end quote, around returning to work. She wrote that her psychiatrist had prescribed medication to help her. The defendant was initially diagnosed, according to her husband, with generalized anxiety disorder. She was then evaluated at the Women and Infant Center for Women's Behavioral Health in Providence, Rhode Island on December 20th, 2022. There, after an evaluation, she was told in the presence of her husband that by psychiatrists that she did not have postpartum depression and that she had no symptoms of postpartum depression. She wrote in her journal that at times she had suicidal ideation in December of 2022, and she also told her husband that she had suicidal thoughts and on one occasion had thoughts of harming her children. But she did not write or voice those thoughts after a stay at McLean Hospital. When she had those thoughts, she consulted with a psychiatrist and with her husband, and then she committed herself to McLean Hospital on January 1st, 2023. She was discharged by the hospital on January 5th, 2023, and the hospital did not file any paperwork at that time attempting to have her committed as a danger to herself or others. She also kept meticulous and detailed daily medication logs in a diary that she wrote. She detailed that she had difficulties with each of the medications that were prescribed to her. And when she had issues with those medications, she detailed how her doctor had her stop that medication or wean off of it and then try something else. They were trying different medications to see what would work for her, what would benefit her. According to her husband, she was never on more than 4 to 5 medications at one time. And at the time of the murder, she was taking only 3 medications. And he said to the police that she always took the medications as prescribed. After her stay at McLean, the defendant appeared to be getting better, according to her husband. She slept well, interacted with friends and family. She went out with her kids and husband to places like the Kingsbury Club in Duxbury, the Charlie Horse Restaurant, the Museum of Science in Boston, the Cape Codder down the Cape, interacting with her family and the public without any apparent difficulties. She even stayed alone with the children on several occasions without any issues in January of 2023. Her husband asked her in mid-January, "Are you still having suicidal thoughts?" And she said no. The defendant's parents visited the family the weekend of January 21st, 2023. They interacted with the defendant in person. The defendant was able to run errands while her mom watched the children. She texted back and forth with her mother, and there was nothing out of the ordinary about these text messages. In fact, the defendant texted her mother on January 22nd, 2023 to ask how her ride home went. During this conversation, the defendant's mother wrote, quote, "Enjoyed seeing everyone this weekend. Nice to see you doing better," end quote. On the night of the killings, Patrick Clancy was interviewed by the police at Beth Israel Deaconess Plymouth Hospital. He told the police that the defendant was having one of her best days. She was smiling and happy, and there was no indication that she was going to harm the kids. No one at all described her as acting like a zombie in the days leading up to the murder or on the day of the murders themselves. On February 5th, 2023, this past Sunday at 1:35 p.m., while sitting with Dr. Paul Zeisel, the psychologist hired by defense counsel to evaluate her mental state, the defendant used Dr. Zeisel's cell phone to call her husband. She left a voicemail stating that she loved him. Yesterday, on February 6, 2023, at 10:09 a.m., she again used Dr. Zeisel's cell phone to call her husband. This time he answered, and during this call, the defendant stated that after he left the house that night, she killed the kids because she heard a voice and had, quote, "a moment of psychosis," end quote. He asked her what voices she heard, and she said she heard a man's voice telling her to kill the kids and kill herself because it was her last chance. Patrick Clancy told the police the defendant had never heard voices before. He also told the police the defendant had never used the word psychosis to him before. The first time she used that word psychosis was when she was with the doctor hired by defense counsel and using his cell phone. The defendant actually wrote a note on her phone on October 25th, approximately 3 months before this happened, October 25th, 2022. She wrote, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all of my kids." She then wrote that she wants to have more kids eventually. The children were killed by ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds up to a minute. The more the victim struggles, the longer it takes. After the victim is unconscious, the ligature must be held in place with force, squeezing the neck for up to an additional 4 to 5 minutes to cause death. Therefore, she had to strangle each of them to unconsciousness and then make sure the bands were squeezing their little necks for several minutes. She could have changed her mind at any point during that time and removed those bands from their necks, and she did not. The defendant did not take advantage of the situation when her husband left the home that night. She created the situation, and she used Apple Maps to make sure she would have enough time to strangle each child before her husband returned from where she had sent him. The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom. She did so with deliberate premeditation and extreme atrocity and cruelty. And to supplement what the defense counsel has provided, I have a statement of real evidence to file in support. And domestic violence. Thank you, Your Honor.
Thank you very much. Attorney Reddington.
Thank you very much, Your Honor. Your Honor, my request is that the court not enter what I would suggest is an inhumane order, ordering this woman to be incarcerated. We all know, as people that work in the system, that jails and prisons are woefully deficient in medical care of the most basic type. We all know that this is an individual, as Your Honor knows from Dr. Ricard's letter, who is in dire medical condition. We all know that this woman is, as counsel concedes apparently, a danger to herself. I question whether she would ever make it to a trial. She's suicidal. She's extremely emotional. However, she's unable and has been unable to express any happiness or sadness or cry. And in fact, sometime about a month or two ago, she made the comment, "I just wish that I could feel something." Now, our society fails miserably in treating women with postpartum depression or even postpartum psychosis. It's medicate, medicate, medicate. Throw the pills at you and then see how it works. If it doesn't work, increase the dose or decrease the dose. Then end up trying another combination of medications. We're talking a relatively short period of time from when that baby was born in October up until January, when this incident occurred, Your Honor, that she was on such significant dosage of medication. Your Honor knows that Cora was born in 2017. It was a very uneventful, normal pregnancy and delivery. No issues afterwards as far as anxiety. Dawson was born in 2018. Again, it was a normal birth. She had no significant issues as far as anxiety. She did have to have stitches and she was sore, and that was about it. Then, of course, Callan was born. When Callan was born, she ended up becoming depressed, suffered from significant anxiety, as a result of which she consulted with a number of doctors. A number of doctors indicated that she would be able to sleep, she would be able to feel, she would be able to emote once these medications kicked in. And again, as I say, our medical in our society completely abandons women with this condition. It's easy to say, come on, you have a healthy baby. You have a wonderful husband. You're able to take care of your kids in your home. You're lucky. Take the pills, you'll be okay. Well, they put her on a number of medications. They put her on Prozac, which Your Honor is well aware is what's known as SSRI, selective serotonin reuptake inhibitor. Your Honor knows that along with some of these medications, they have the black box warning from the FDA, may cause suicidal ideation, may cause homicidal ideation. She was on Ativan. She was on Benadryl. And then she ended up being told, okay, because she was complaining about the effects of the Prozac, they said, stop the Prozac, we'll find something else. They put her on Remeron. Then they added on Seroquel. And Your Honor, I attached from David Benjamin, the toxicologist, some papers with the submission, and Your Honor can see the side effects that this Seroquel causes. She was having bad thoughts. She was having worsening depression. Her husband suffered through that phase. Her parents were well aware of the fact that she was suffering from this depression and depressive phase. She wasn't sleeping. She ended up, at some point, Your Honor, December 31st, she was on Seroquel. They told her then the Valium would be stopped. She was a shell of herself, no personality, and went to the doctor again. The doctor again prescribes the Seroquel, and then they took her off the Seroquel. And then she went to the doctor, and at that point, they prescribed trazodone, Ativan, amitriptyline, right up to the very end, when she was so bad that she voluntarily turned herself in, if you will, to the McLean Hospital. We know that that's a psychiatric hospital. She was at the McLean Hospital for a period of about 5 days. Well, at the McLean Hospital, they basically tried to get her off the Seroquel. She wanted to get off the benzodiazepines. She felt that she was being addicted to the benzodiazepines. She then ends up on trazodone, Ativan. Her mood was terrible after she got out of McLean Hospital. She still had the suicidal thoughts. As the government has indicated, she even told her husband that she had suicidal thoughts. You think this is something that she's planning to kill these 3 kids by going and getting a menu, going onto Google Maps or whatever it is, and finding out the distance? When she tells her husband she's having suicidal thoughts, probably a month prior, thoughts of hurting her children, they go to the doctor again, and she's on the medications, on and off, on and off. This is a significant issue between the postpartum depression as well as possibility of postpartum psychosis that is pretty much ignored. But nevertheless, with the overlay of the SSRIs and the history, and Your Honor has some emails and things that people would reach out to me from all over the world, indicating that their daughter had the same problem, that they had the same problem. Your Honor is well aware that many times when people are on Prozac or on SSRIs, workplace violence, homicides, family homicides, This is clearly a tragic, which is a word that's used too much in the criminal justice system, but this really is a tragedy in this case. So we have, obviously, I would suggest, a very good defense for this young woman. She's 32 years of age, Your Honor. She met her husband. He was the love of her life. They got married. Wonderful young couple. And as counsel noted, she always wanted to have kids, always wanted to have babies. She's a nurse. She went to be a midwife because she wanted to help other women that would be in having babies, but didn't want to have all the medications. She was not a big medication person. Your Honor saw, I think there's probably close to 50 letters that have been submitted to you, and I know you read every one of them. The incredible outpouring of support by other nurses that work at Mass General Hospital. The fact that these women have a vigil, that they write the letters to this court imploring you to understand that you sentence, as far as bail issue, the woman before you, who was a beautiful person, who was thoroughly destroyed by these medications. That's for another day, obviously. A bail issue, bail argument. Your Honor is well aware under Commonwealth versus Vasquez at 481 Mass 750, Supreme Judicial Court indicated that this court, or the court, has vested in sound discretion of the bail judge. And the main considerations would be obviously the usual bail considerations: nature and circumstance of the offense, likelihood of success on the defense, roots in the community, and of course, as the in Vasquez case, as well as Commonwealth versus Herring, 489 Mass 569, defendant's risk of flight. So now you have a situation, Your Honor, where this woman has incredible support, as you saw, letters from Foxborough that were signed by about 15 women, letters from her family, friends, letters from people she's known since the 6th grade that have stayed in touch with her. One thing that's a theme that is readily apparent is that Lindsay loved her children, that she would always, one of the letters said, she would always rub her belly, rub her belly. She had pictures of her pregnant standing next to Patrick, hanging on the wall. I was in the house. The house is absolutely loaded with indicia of love for those kids. Photographs on the wall, little drawings, all sorts of games, toys, playpens, bassinets in the living room, in the dining room, the kitchen loaded with toys. Virtually the entire house, including their master bedroom. Toys, things for the kids. This is not a situation, Your Honor, that was planned by any means. This is a situation that clearly was a product of mental illness. Now, under the Vasquez case, one of the issues, as I said, is whether or not there's a risk of flight. Now, I did submit to Your Honor a letter that was written by her physician, her attending surgeon, Nakul Rekha. This doctor was in surgery until 8:30 at night and actually took the time to write this letter for you to review. And I just want to make note that he makes reference to the fact that she is now in her 12th day of hospitalization following admission on January 25 after a 20-foot fall. She suffered, unlike when the government Friday was saying that she can move her legs and she's getting better, she's okay. No, she's not okay at all. He indicates that she suffered several severe spine fractures, including spinal cord transection. You know what that means. At the level of T5, T6. As you know, she had surgery for this from the orthopedic spine surgical service who performed a decompression infusion. Unfortunately, she is not expected to recover meaningful function at this point below that level of the spinal cord, which makes her a paraplegic, unable to move her legs or feel sensation from below her, he refers to umbilicus or belly button. He says she has no function below this level. Additionally, less active issues include rib fractures in the chest, both sides, cervical spine fractures, necessitate the wearing of a collar around her neck due to the cervical spine fractures. She's paralyzed. The doctor indicates that she needs significant medical treatment. Doctor recommends that she would be discharged to Spalding Rehab. Now, you know that we have Spalding Rehab. You know that we have the Worcester Hospital. This court is vested under Vasquez with your authority to have this woman not held on bail. Perhaps put a GPS on her, I guess, if someone's concerned that she's going to miraculously recover, which isn't going to happen. As Your Honor knows, being a paraplegic, paralyzed, she can't move. Can't get off the bed. She can't walk. She can't even go to the bathroom. She has to have 24/7 medical care. Her emotional state is so bad that there's a significant fear of suicide. She has to have someone sit in the room 24/7 to watch her. They don't talk to her. They're not, chatting it up. They just sit there and watch out of that concern that she would commit suicide. So you have a paraplegic who can't walk, who is definitely a danger to herself, and the government wants to put her in where? Framingham State Prison? Plymouth House of Correction? There's no way that any humane person would do that, especially within the structure of our criminal justice system, where a person is presumed innocent. And I'm not suggesting with the facts that the government has read, but she has a good defense. She's got a darn good defense to this case because that's what happened. And I just want to share with you, Your Honor, one of the things that's interesting. When I was in the House, I came across a drawer that had a bunch of pill bottles in it. And I called the DA and I said, I got these pill bottles. And we made arrangements. I'm going to be giving them to them. And it's all the Prozac and the Trazodone and all that stuff. But inside the drawer was this little vase. And I didn't know what it was. It just looked like a little vase to me. And my wife said to me, oh, that looks like a wish base. I said, what's a wish base? She said, when people write down little wishes and they put little pieces of paper and they put them inside the vase. And there are literally dozens of these little pieces of paper that talk about Lindsay's wish for happiness and health for her children, that she could get pregnant again, that she would be able to be with her children, little Colin, Dawson, Cora, that they would be happy, healthy, and successful. This is not a woman, Your Honor, that had any reason to harm those innocent children. My request, Your Honor, is that the court would put her on a GPS if you feel that's required, and let the doctors continue to treat her, let her go to Spalding Rehab. She will sign a waiver that allows probation at any time to speak with her treating physicians or social worker, find out how she's doing. Does it look as though she's getting close to regaining the ability to walk, which she isn't, but nevertheless, they would be able to do that. And then the government would be notified, and they can come back in here again and try to hold her without bail. And my request would then be to Worcester for the emotional and the mental illness aspect. I don't think that it's fair or just or consistent with our duties to each other as human beings to put her in jail. I'm asking that she be allowed to continue with her medical treatment, Your Honor.
Commonwealth.
Your Honor, if I may, I did look into medical treatment if she's held. We were under the impression we had received information before that she could move her legs, but then we learned updated medical information that she, for the time being, is paralyzed from the waist down. If she is held, she could go to the Shattuck Hospital. If Shattuck does not have what she needs, she can be sent to another facility, and the corrections officers would go with her there. Shattuck would actually work with her, the doctors at the hospital she's currently at, to determine the best course of treatment. And if whatever she needs, she's going to get. But as defense counsel said, she is a danger to herself and, from the Commonwealth's perspective, others. And just because she is paralyzed does not mean she's not a flight risk. She will be in a wheelchair eventually, and she can be driven somewhere. She can be flown somewhere. It does not mean that she will never be able to leave this area.
Just would like to say that yeah, sorry. Thank you. I have been, unfortunately, in the Shattuck Hospital. To suggest that she can get, quote, what she needs from the Shattuck Hospital is absolutely not true. The care that she's receiving at the hospital she's at now and the care that she would be receiving at the Spalding Rehab are light years ahead of the dismal, dank conditions of the Shattuck Hospital that we put our prisoners in. It's like something out of Iran, and that's not fair or correct.
Thank you both. Both of you, all of you who appear before me that will be litigating this case are all very well respected. And I'm sure at some point in time in Superior Court, this case will be tried in a very professional and very well by both sides. As counsel stated in Commonwealth v. Vasquez, the Supreme Judicial Court addressed the issue of bail in first-degree murder cases, and Justice Lowy issued a detailed decision about the issues in these types of cases. The court found that a defendant charged with first-degree murder has no right to bail, but may be admitted to bail in the discretion of the judge. The court ruled that a judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weaknesses of the Commonwealth's case and the potential penalty of a sentence to life in prison. The court further noted that appropriate considerations for a judge would include the defendant's family ties, financial resources, length of residence in the community, character, mental condition, record of conviction, appearances at court proceedings, or any previous flight to avoid prosecution or failure to appear at any court proceeding. It is important to note that the purpose of bail is not to impose punishment. The court has conducted a careful review of the details of the case and the defendant's history. The court's reviewed the filings that have been made, as well as letters submitted by counsel for the defendant and the update that was received from her attending trauma surgeon. The factual allegations in this case are both horrific and tragic. The potential penalty faced by the defendant, if convicted, is severe. The defendant has no criminal history. She does not even have a driving record. There is no evidence of any history of any abusive behavior by the defendant. The defendant was raised in New England and has extensive ties to the local area. She has an extremely supportive family. She had worked for several years in a local hospital, and a number of co-workers have written letters in support of the defendant and her character. She is described in these letters as an exemplary worker, colleague, and friend. In the letter submitted by her attending trauma surgeon, she has extensive injuries that will require long-term inpatient rehabilitation. Weighing what the doctor has written and the facts in the defendant's current condition, the court finds that there is minimal risk of flight given the defendant's circumstances. The court is going to make the following order on bail. The defendant shall remain in her current hospital until medically cleared to be moved to a new facility. As a condition of bail, the defendant is ordered not to leave the hospital until discharged to a new facility. The defendant shall provide notice to probation 48 hours in advance of any transfer to a different facility. Based on the letter of the doctor, it would appear likely that she would be sent from the hospital setting to a 24/7 rehabilitation facility, like the Spalding Rehab. As a condition of bail, if sent to a 24/7 rehabilitation facility, she is ordered to remain in that facility, with the exception of if she needed to be transported to a different medical facility or a hospital for an additional MRI or something like that. The defendant shall continue to receive mental health treatment while hospitalized and sign releases for probation to monitor compliance with counseling. In the event that the defendant were to complete the services at a 24/7 rehab and complete that care, the court would hold a further hearing as to whether or not the defendant were in need of further mental health treatment that would need to be done in an inpatient setting, or whether or not the defendant's mental health care could be provided in a residential setting. The court would direct court clinician, court doctor, to consult with the defendant's mental health providers to conduct this evaluation at the appropriate time in the future. If the defendant were in a position that she was going to be discharged to a residential setting, both sides would have the opportunity to be heard further. Any discharge in a residential setting, the defendant would be subject to home confinement with appropriate electronic monitoring to monitor home detention. There would be exclusions that would be available if the defendant needed to attend medical or rehabilitation appointments, counseling sessions, or religious worship sessions. The court would have probation visit any proposed residential setting prior to the defendant being discharged to that type of a setting to ensure that such a setting was appropriate and safe. The defendant is ordered to surrender her passport to probation. In the event that the defendant does not have a passport, she is prohibited from applying for a passport. The court is not going to set any monetary bail at this time.
Your Honor, would the court order that any such residential setting be in Massachusetts? I don't think we could do monitoring outside of the state.
If we get to that point, you may make that request. If it becomes an issue, we can deal with that. We clearly have the ability in Massachusetts to appropriately monitor. If for some reason, I know that there are relatives that live in Connecticut, if something like that were being requested, obviously the court would need to make sure that appropriate monitoring were in place, but both sides would have an opportunity to be heard regarding that request. The next step in this matter would be to schedule a probable cause hearing. Is there a date that the parties would like to suggest for that purpose?
Hold me a second, Your Honor. It's going to take some time to,
That is fine.
gather records. Thank you.
Obviously, I would believe that it would be highly probable that the Commonwealth would be proceeding by way of indictment to the grand jury. In the event that the defendant is indicted, counsel for the Commonwealth will notify Attorney Reddington and make appropriate scheduling for arraignment in Superior Court.
Very good.
There was a matter that I'm not sure if the parties need to address. There was an impoundment order as to a document that was signed by a previous judge. Do either of you wish to be heard on that?
I think by agreement at this point, we'd ask that all impoundment orders be extended and that defense counsel be allowed access to copies of the documents.
It appears that Judge Sullivan had issued an order specifically as to one document, and that order will remain in effect. It may be readdressed at the next court hearing. As far as what is in the, as it would relate to the doctor's report or any of the letters.
I don't have any request to impound the documents filed today, Judge.
Okay, that's fine. And obviously, the documents submitted by the Commonwealth would become part of the court file, as would be the application of complaint and documents that were attached to it submitted in support of the complaint. Yeah.
Your Honor, signatures and probation execution issues to counsel.
Yes, counsel for the defendant may sign the conditions of probation. The conditions of probation have been read to the defendant, and they're clear. If there's any issues, they can be addressed on a further court date, but those will be the conditions that the defendant is subject to, and counsel can sign on her behalf.
Thank you very much.
Thank you, Your Honor.
Ma'am, on docket 2359 CR 153, the court has released you, ma'am, on conditions. You must remain in the hospital facility until medically cleared. You're not to leave unless discharged. You must submit notice to the probation department for if transferred from any facility. Must receive mental health counseling, sign releases for probation. The court notes a rehearing may occur if conditions change. Home confinement upon medical release. Allow visits, home visits by probation, and surrender passport. And the previous impound order has been extended to the next date. Case will continue to May the 2nd, 2023 for probable cause.
Thank you.
Thank you all very much.
Thank you both.
There's so much from that arraignment that stuck out to me, but one of the main things was Lindsay Clancy herself. While she was covered with a mask, she just appeared to be void of all emotions. Only once did she scratch her face. That was, besides blinking, the only thing we saw out of her. Is that the effects of medicine that she's on? I don't know. I know this case is going to be a tough one, guys, and my heart goes out to everyone who is suffering or has suffered from postpartum anxiety, depression, psychosis, any of those things. There was a GoFundMe that was created for Patrick. Now, in it, it lists that it was for, the baby's funeral, medical needs, and potentially for legal defense. That GoFundMe has now raised over $1 million. Since this video has gotten so long, I'm going to go ahead and read that out in a separate video. Let me know in the comments below what you guys think about the Lindsay Clancy case, and I'll catch you on the next one.